Lecture 4: International Law and Municipal Law. The role of municipal rules in international law. The general rule with regard to the position of municipal law in the international sphere is that a state which has broken a stipulation of international law cannot justify itself by referring to its domestic legal situation. It is no defense to a breach of an international obligation to argue that the state acted in such a manner because it was following the dictates of its own municipal laws. The reasons for this inability to put forward internal rules as an excuse to evade international responsibility are obvious. Any other situation would permit international law to be evaded by the simple method of domestic legislation. International law before municipal courts. The problem of the role of international law within the municipal law system is, however, rather more complicated than the position discussed above, and there have been a number of different approaches to it. States aren't, of course, under a general obligation to act in conformity with the rules of international law and will bear responsibility for breaches of it, whether committed by the legislative, executive, or judicial organs in irrespective of domestic law. Further, international treaties may impose requirements of domestic legislation upon state parties, while binding Security Council resolutions may similarly require that states take particular action within their jurisdiction. There is indeed a clear trend towards the increasing penetration of international legal rules within domestic systems, coupled with the exercise of an ever wider jurisdiction with regard to matters having an international dimension by domestic courts. This has led to a blurring of the distinction between the two previously maintained autonomous zones of international and domestic law. A re-evaluation of the role of international legal rules and a greater preparedness by domestic tribunals to analyze the actions of their governments in the light of international law. Further, domestic courts may often have to determine the meaning of an international rule that is relevant for a case before them, or to seek to resolve conflicts between international rules, such as that between state immunity and the prohibition of torture, and that between treaty rules of human rights and binding Security Council resolutions. States aren't, of course, under a general obligation to act in conformity with the rules of international law and will bear responsibility for breaches of it, whether committed by the legislative, executive, or judicial organs in irrespective of domestic law. Further, international treaties may impose requirements of domestic legislation upon state parties, particular action within their jurisdiction. There is indeed a clear trend towards the increasing penetration of international legal rules within domestic systems, coupled with the exercise of an ever wider jurisdiction with regard to matters. International law, municipal law, international law became more and more important in international relations, and the amount of international conventions as well as legal norms has been multiplied in the last centuries. Until the 19th century, law was only dependent on the will of sovereign states and was accepted by the national authorities. That confused the scholars whether the application and follow of international law depend on the will of the sovereign states or not. Besides, how the conflict between international law and domestic law can be resolved. The main scholars of monism are Hegel and Kelsen. So monism refers to international law and domestic law as the same. So there is no theoretical problem to apply international law. Hegel, the German thinker, analyzed the issues, and according to that particular school of thought, international law was a branch of state law, and the compulsory character of international law was derived from the convergent will of all states. Scholars of that period conceived international law as common law of nations. The dualists considered international law and domestic law as different. International law based upon agreements between states and customs. One of the scholars, Trifle, used international recognition in the field of international law throughout his work International Law and National Law from 1899, Voltaire to Landesrecht. Developing the consequences of the concept of sovereignty, Trifle examined the relationship between international law and national